Good evening, Mayor and Council. My name is Keith Leitz. I'm the City Attorney. One thing Chief Lewis failed to mention in his intro is he's also a fantasy football champion, and I didn't mention that in his swearing in, so that's my my second chance at it. So, judging by some of the public testimony earlier, it may be a little bit of a misconception about what this is about. This is the third update, and it's primarily a legal update to kind of give what the contours are surrounding homelessness, and that includes some support functions. It is mostly through a legal lens, but we do have a staff member who's part of their job, their position is working on homelessness issues. We have a working group of staff that meets. I also attend a monthly international working group looking for homelessness solutions. So even outside of what you're seeing in this presentation, there's a lot more kind of going on behind the scenes with that. So that's my intro, because I'm not a fantasy football champ. Okay. So as we go through, if you have questions, please feel free to stop me. You will see a lot of these slides are very familiar. There haven't been updates on a lot of them. If it's your first opportunity, then I'll try to make sure I hit everything despite that. So for relevant case law, the biggest case and what drives most of our of what we're allowed to do with homelessness is Martin v. Boise. That applies only in the Ninth Circuit. We are in the Ninth Circuit, so it applies to us. And I'll go into that case a little more later. Blake v. Grants Pass is another case that kind of expands on Martin v. Boise. Blake v. Grants Pass is still in process. It was argued at the Ninth Circuit, and they're expecting a decision by the end of this year. But there's no case law from that case. We're just watching it to see what happens. And then Bilodeau versus City of Medford is actually a new class action case. So it hasn't even gone to certification yet. It's very early on in the process. And then Seattle v. Long is a Washington State case, but that's kind of, it was recently decided, it was decided last year, and that one applies to vehicle camping. So that's what the case we look to for kind of some guidance. It isn't law in Oregon, but our statutes are similar enough that it would likely be interpreted the same way if the court looked to that decision. We'll also look at some Oregon legislation. We'll go over what our current ordinances are, some things to consider if we want to make adjustments to those ordinances. And TPMs are time, place, and manner restrictions. And then another opportunity for questions. So I talked a little bit about Boise. This set the standard of not being able to cite people who are involuntarily homeless. So basically the holding is a city ordinance prohibiting individuals from sleeping outside on public property may violate the Eighth Amendment when enforced against homeless individuals who have no access to alternative shelter. And so what that means is you have to have bed space for people to sleep. You can't criminalize sleeping, particularly if they have no other place to sleep. Does that make sense? This was an Eighth Amendment and 14th Amendment case, if you're curious about that. Like I said, it only applies in the Ninth Circuit. I haven't seen a corollary case in other circuits. It was petitioned to the Supreme Court and they declined to hear it. So basically what happens now is the law stays this way in the Ninth Circuit. If another case that is resolved differently in another circuit comes up, that's when the Supreme Court would be more likely to hear that case because there would be a split between circuits. That takes a long time. So there could be one out there, but I wouldn't, it takes a long time. That makes sense? Let's see, so following that, we had Grants Pass, and what Grants Pass did that's different than Boise is it made even the threat of a possible fine unconstitutional. So Boise, they were actually fining people for sleeping in the park. Grants Pass had kind of a construct where people could be trespassed and maybe receive a violation notice that didn't have a fine attached. They would just be excluded. If they collected enough, that would then change to a criminal offense. And so the court said, essentially, because there is a path to a criminal offense for the sleeping violations, that you've criminalized sleeping. So it kind of expands Grants Pass a little bit. Again, that one's on appeal, and we're not expecting a ruling until the end of the year. Bilodeau, so this one is a time, place, and manner case. Essentially, Medford, one of the things they did is they set up exclusion zones where people were not allowed to sleep, particularly during certain times, like if there was a high fire danger. I think they also included playgrounds and battlefields as exclusion zones. And so that case, the premise it would be whether or not they would be allowed to do that under reasonable time, place, and manner restrictions. There's some significant dispute in that case about whether or not Medford actually has enough shelter space in order to enforce their ordinances anyway. And there's also some discussion in that case over what a low barrier shelter actually is. So that there's some interesting issues that could be resolved in that case, but again, it's very near the beginning. And then Seattle versus Long. This was a gentleman who had a pickup truck that he was living in, parked in a city parking lot that he wasn't paying the parking for. It accumulated some violations to the point where the city towed the vehicle. Case went, like I said, up to Washington's Supreme Court, which ruled against Seattle and said that was a violation of the 8th Amendment because they towed the vehicle that he was living in, and he didn't have the means to get that back. Some legislation since last time. So this was on here, but in the last update, but it wasn't actually signed into law yet, and this has now been signed into law. Basically, if it doesn't have to be police, it could be police, parks, it could be ODOT, but whoever, if they're going to remove personal property, it used to be that you had to post for 24 hours ahead of that. They've extended that now to 72 hours. They also I guess, tidied up the definition of personal property. It's now any item that can be reasonably identified as belonging to an individual that has apparent value or utility. They made some items that are categorically not personal property, like hazardous material, soiled items, things like that. House Bill 3115. This is the House bill that it's now law, but it's not in effect yet. And this is what will set our new, how we draft time, place, and manner restrictions going forward. And basically this comes straight out of the bill. Any city or county law that regulates the acts of sitting, lying, sleeping, or keeping warm and dry outdoors on public property that is open to the public must be objectively reasonable as to time, place, and manner restrictions with regards to persons experiencing homelessness. What this did in large part is put into the statutes the holdings from Martin v. Boise, and why that's kind of important is even if that Martin v. Boise case was overturned in the future at the Supreme Court, it wouldn't really matter that much because we now have the language in our ORS. Does that make sense? So these haven't changed. These are our current ordinances. and largely are not enforceable because of Martin v. Boise and, well, really because of Martin v. Boise. This is actually the ordinance that sets when our parks are open. Again, not really enforceable the way it's written.
It wouldn't be enforceable anyway, according to state law, right?
Once that law goes into effect. We, in the meantime, what we can do and what we're working on is, and what you heard about a little bit from, about what Ben has done, we can draft procedures, reasonable procedures that we could put in place that we could do some things. It's pretty limited, but especially with our level, and I'll get into it a little bit later, but our current lack of shelter space. So that, like, when people look to other cities and say, but they're doing this, you gotta look a little deeper and see, oh, they also have shelter space or other programs in place. This slide's largely similar to what we've seen in the past as well. It's just things to consider for future ordinances. Low barrier shelters are I guess from the enforcement standpoint, they're the best solution because it allows more people to go there. When you're talking about a homeless individual's ability to go to a shelter, it's always an individual assessment. So even if we had a low barrier shelter with room, that the person that you're talking to that's sleeping in a park, that they could have been trespassed from there. There could be another person staying there that it would create a restraining order issue. So it really is individual, even once you have all of these solutions in place. The next is high barrier shelters, and these, again, it's all helpful. It's all helpful to help people get off the streets, but from an enforcement standpoint, high barrier shelters help because they ease the burden on the system. Even if someone can't get into a high barrier shelter, maybe there's someone who's in a low barrier who's able to transition to like Bethlehem Inn, and that frees up a place in a low barrier shelter. So all these solutions kind of work together. The next would be something like Oasis Village or some other designated area for sleeping, camping, and or RVs. The key on this is there has to be a reasonable area. I think someone talked about people being a long ways from services. That's definitely a consideration on whether a designated area is reasonable or not. It can't be that you're shutting everything down and then just putting one area on the far end of the city and that no one can get to or get to other kind of places where they could get services. So that's all stuff that has to be looked at when you're designating an area.
Hey, Keith, a question in this one. We have several camps that are quite a ways outside of town, say 2 miles, 3 miles. And if we have a facility that's closer in, right, does that then fix this problem? Because, I mean, if they'll ride their bikes 2 miles into town, is it reasonable to assume they can ride their bike 1 mile into town?
I mean, closer is better. So, the closer something is, a site is to services, the better. And there isn't like a magic line. There is kind of a magic line, I guess. The magic line for cities is it has to be within the city. So even if it was close but just outside the city, you can't count that. And I guess so that makes me kind of, a lot of those places are already outside of the city, so I don't know that would, it would be kind of an interesting calculus, I guess. One of the other things from the Grants Pass case, the court mentions that you can continue to enforce non-sleep related violations. That's more difficult after 110, but there are some, offensive littering, public urination, some other anything that would be a crime that is not directly associated with sleeping. So that is everything in the
Okay.
update.
Well, thank you. Anyone else have any questions?
Mayor,
Counselor? Yeah.
so when you go over the testimony we had earlier, and we've had multiple emails about the RVs and cars that are on the public streets, and one of the things that came up was, is there a possibility of an interim solution that we can do right now and address this without a long delay? Because who knows when the Oasis project would be available? Could be a year, could be 2 years. So one possibility is using the old Juniper Golf Course. There is an area there where the old cart sheds used to be, and it's not right on Veterans Way. It can be screened a little bit. It should be flat because that's where all the carts were. And my recommendation would be that we look at something like that as an interim solution and help the people in Northeast Redmond, help the people by the rack, these other residential person who called at the last meeting. But it would require a bullet train rather than a stagecoach or horse and buggy approach. And I don't think it would cost a lot of money, and it would help a lot of people and provide a place where there's maybe a couple of porta potties or something, but it would solve this interim problem that we have that's right in everybody's face, and we hear about every single meeting. So my recommendation is that we pursue something like that because it's just going to get worse.
If I can respond, there is a team right now working on that very issue, Counselor, trying to find an interim solution until such time as we see Oasis Village up and running. So our city manager, our city attorney, police, myself, others are on that.
But I do think that it requires speed. It can't go on a, we'll look at it in a couple weeks, and then we'll look at it in a couple months.
Right.
It has to be done as soon as possible.
Thank you. Keith, anything further?
No, I think it's everything. I know it doesn't make either side of this issue, this presentation, doesn't help any, or make anyone very happy. I don't want to, be cold towards either side. It's just kind of the contours of the laws that we're working with right now, so.
And I had asked our city attorney to bring us up to date on the latest that's out there. Okay,